Today's webinar is the book launch for the Cambridge University Press book AI and Private Law, edited by Professor Ernest Lim and Dr. Phillip Morgan. We are very, very pleased to be able to host this webinar for the launch of that book, as well as to gather views from the industry. And today will be represented by someone who's working in the industry, as well as someone in asset management, in order to feedback and give their views on business risks, the use of technology, especially AI, as well as the legal implications and legal risks. So in terms of today's proceedings, I will be opening the floor by introducing the event. My name is Chiu, and I'm director for the UCL Center for Ethics and Law, which is the center bringing you today's webinar. And our distinguished panel today is giving up an hour of lunchtime to regale us with this excellent, magnificent volume, as well as to provide thinking on forward-looking visions regarding business risks and AI. I will introduce the speakers briefly. Their full biographies are available on our event registration page. As mentioned, this webinar is recorded and will be available for YouTube streaming in due course. We would like to invite questions only to be addressed towards the end of this webinar. So the order of proceedings will be that our editors of the book will make an introduction first, with Professor Lim, followed by Dr. Morgan in that order for about 10 minutes each. And then following which we'll be inviting Dr. Raphael Reims, who is with BMW. He's a lawyer and compliance expert at BMW, to talk about industry use and his views and thoughts, followed by Nick Pelosi, who is Associate Director of Engagement in North America with EOS Hermes, where he leads the engagement team with in the tech sector on digital rights. So we will be hearing from each of these panelists in turn for about 10 minutes each from all of them, following which we will be then addressing the questions that you might have. Throughout today's proceedings, please feel free at any time to submit your questions via the Q&A function, and I'll be moderating them towards the end of the webinar, where we hope to have 10 to 15 minutes to address your questions. So before we start, let me introduce the first speaker of the day. Professor Ernest Lim is Vice Dean and Professor of Law at the National University of Singapore. He's a prize-winning researcher and has published extensively on corporate governance and law and technology. And he's, of course, the editor of this magnificent volume on AI and private law, to which I had the privilege of contributing as well. Without further ado, can I first give the floor to Ernest?
All right, please allow me to share screen. Okay. Many thanks, and thank you all for joining. It is a trite fact that transparency and explainability are among the key principles or guidelines regulating AI that have been set up by major governments and organizations. And transparency refers to the communication of appropriate information about an AI system to relevant people. Explainability refers to the extent to which it is possible for relevant parties to access and understand the decision-making processes of an AI system. But what does transparency and explainability of AI systems mean in the context of private law? What is private law's response to these principles? There's surprisingly little critical analysis of these questions. Now, so rather than giving you a summary of each of the 29 chapters in this handbook that span the law of obligations as well as corporate and commercial law, I think it's more interesting if I give you a taste of this handbook by briefly examining how transparency and explainability play out in 5 areas of private law that are covered in the handbook. Causation, contract law, consumer protection law, insurance law, and commercial dispute resolution. Now, causation is a critical doctrine in private law remedial liability. In claims for compensation, the claimant must show a causal connection between the defendant's conduct and the claimant's loss. Since due to a vitiating factor, the claimant must establish that the vitiating factor caused him or her to enter into the contract. Sandy Steele, in his chapter, asks us to consider a hypothetical. Suppose an AI system is tasked to buy shares in a company. Assume that the issue is whether the AI system relied on false statements made by the company whose shares it bought. How do you show the company's misrepresentation had a causal impact on the AI's decision to buy the shares? There can be two answers. First, the easy and I think misconceived answer is that the AI system is a black box. It is impossible to find out whether, let alone how, the AI system relied on the misrepresentation. The second answer is a bit more nuanced. If the inputs to the AI system at the time of the entry into the transaction were changed to exclude the specific misrepresentation, what would the output have been? This is known as counterfactual explanation. Advances in machine learning suggest that this is possible. But the second answer depends on the fact that we can find out the inputs. What is private law's response if the defendant fails to collect or record the inputs? One answer is that a legal duty should be imposed on the developer to record the inputs. This is one of the approaches taken by the EU AI Liability Directive. But what if it's impossible to find out the inputs, the workings of the algorithms? There are two approaches. The first is to ask whether the breach of duty materially increases the risk of injury or losses suffered. The second approach is that it is possible to have causal knowledge without knowing the precise mechanisms. For example, tort lawyers know that asbestos causes mesothelioma, but not precisely how. Finally, let us consider foreseeability. Now, this is a different principle from causation, but it is often discussed with legal causation, so I should mention it. In tort, the type of loss must be reasonably foreseeable at the date of breach to be recoverable, unless the tort is intentionally committed. In contract, the date is at the formation of the contract. It is reasonably foreseeable that AI systems can make a mistake, but may not be reasonably foreseeable when and why. If that is the case, then any losses will be reasonably foreseeable, and the defendant can never rely on the defense of foreseeability. So the question has to be more nuanced. We have to ask how the harm would have occurred. If it is reasonably foreseeable that the mistake made by the learning algorithms caused the harm, or if it is possible to quantify the risk of such a mistake, then the defendant can't rely on the defense and may be liable for the losses. In short, for these reasons, the extent to which AI system is transparent and explainable has an impact on whether we can establish causation and remoteness of loss in private law claims. Now, moving to contract law, Tony Casey and Tony Nicolette in the chapter argue that AI can fill gaps in the contracts. These are micro-directives, which gather data about the current state of the world and factor in the purpose of the contract in order to update the parties' obligations at the time of performance. One example is dynamic price algorithms used by airlines and ride-sharing apps. What if one party to the contract misunderstands how the algorithm is designed to function? Does that trigger the vitiating factor of mistake, which can rescind the contract? Should the court hold on the basis of good faith that the party who is in a superior position to understand the manner in which the algorithm functions be required to disclose or correct a misunderstanding that the other party has? Therefore, the extent to which the algorithms are transparent and explainable may affect the doctrine of mistake and good faith requirement like law. Moving to consumer protection law. As we know, AI consumer products, namely digital assistants, including Alexa by Amazon, Google Assistant, Siri by Apple, and Bixby by Samsung. One of the issues Judy Patterson considers in a chapter is this: if these AI digital assistants use your data to manipulate your preferences and send you targeted advertising, or recommend you certain products that are outside the preferences that you have specified, do you have any recourse under the UK Consumer Protection from Unfair Trading regulations? which prohibit unfair commercial practices and oppressive practices. Note that unfair practices include not only deception or false claims, but also taking advantage of the consumer when the defendant ought reasonably to know that the claimant can't protect his own interests or can't reasonably understand the transaction. Now, but how do you establish unfair or aggressive practices? You need to understand the inputs into the AI system and the training models in order to find out if your preferences have been manipulated or disregarded. You need to be equipped with a basic understanding of how algorithms work. Thus, the principle of transparency and explainability is relevant when the claimant needs to prove that the defendant has engaged in unfair practices. Moving to insurance law. Insurance companies that use AI claim to be able to provide insurance quotes within minutes and even seconds. AI has been used to allocate individuals to risk groups based on their digital footprint. Under English insurance law, the pre-contractual duty requires the assured to inform the insurer of the matters where a prudent insurer objectively would be interested in such matters. This is known as the pre-contractual duty of fair presentation of risk. To show that the assured breached the pre-contractual duty, the insurer has to show that had the assured complied with the duty, the insurer would either not have entered into the contract at all or would have entered but on different terms. The insurer has to show the correlation between the features of the relevant individual and the predicted loss experiences of that individual, and ultimately agreeing to insure such individual on the terms agreed. This would then reveal whether what was not fairly presented to the insurer had a causal effect on the insurer's decision to insure such risk. But in her chapter, Özlem Gürses states that algorithms are unlikely to provide simple, easily explainable reasons for the insurer's risk assessments that led to its ultimate decisions. Therefore, where an AI entity assesses the risk presented, either the insurer may not be able to establish the assured breach of the duty of fair presentation of the risk, as inducement will not be possible to prove, or if the insurers want to contend that, they will have to find a way to prove on what basis, namely on what data analysis they enter into the contract with the assured. This requires the insurer to know how the AI system has arrived at the insurance policy. Therefore, the principle of explainability and transparency of the AI system is vital to the insurer if it wants to show that the assured has breached the pre-contractual duty of fair presentation of risk. Now, moving on to the last topic, commercial dispute resolution. Anselmo Reyes argues in his chapter that AI will be useful to assist adjudicators in coming up with recommendations or decisions. Adjudications can plug in the facts of a legal problem into the AI system. Predictive AI would then output a decision based on the patterns discerned from a database of statutes and cases. To address automation and anchor biases, adjudicators must know the cases and statutes relied by AI to generate the decision. To use AI to assist in adjudication, the decision makers need to have a basic understanding of the algorithms deployed. What if there are biases in the algorithms or doubts on the cases and statutes used by the AI system? Reyes suggests that if a party is unhappy with the default system being used by the adjudicator, it should be allowed to challenge the algorithms during the relevant proceedings. This may be similar to how expert evidence is being challenged in courts. Therefore, explainability and transparency will be important if we want to rely on AI to assist with adjudication. To conclude, at the heart of the development and use of AI is responsibility. But responsibility raises different questions and means different things to different private lawyers. What responsible AI means to a competition lawyer is different from what it means to a corporate lawyer or a trust lawyer. For example, to the corporate lawyer, the question is not whether a robot director can be liable, given the difficulties with giving legal personality to AI system, but whether directors will be in breach of the duty of care if they fail to use AI, or if they use, the company incurs losses. What safeguards should the board of directors put in place when they use AI systems? To the IP lawyer, the question is not whether AI-generated outputs are capable of patent or copyright protection, but to what extent can AI-assisted outputs be protected by IP? As for tort law, I shall leave it to Phillip to discuss. To conclude, this handbook does not give you all the answers, but it asks the right questions regarding the relationship between AI and private law. It covers 29 chapters spanning the entire field of law of obligations, IP, corporate and commercial law, and written by common law and civil law experts, including an introduction on AI by computer scientists. Thank you very much.
Thank you. Thank you very much, Ernest, for this taster into the book. Those of you who may want to purchase the book, we have a discount code up on our event registration website. So do please make use of it if you are interested. I shall now turn to the second editor of the book, Dr. Morgan. Dr. Phillip Morgan is reader in law at the University of York. And in particular, I'll mention that he is leading York's new interdisciplinary AI Safety Center for doctoral training. He's published extensively in tort law and has keen research interest in the interdisciplinary dimensions of AI. Over to you, Phillip.
Thank you very much, Iris, and thank you very much to everyone present today. The book is available from all good booksellers, and today I'm going to be discussing and focusing on part 1 of our handbook, which is on the law of obligations. Now, the introduction of AI has been widely described as the 4th industrial revolution, and each previous industrial revolution has led to major challenges to the law of obligations and significant legal developments. Most of us who studied law as undergraduates will remember classic cases such as Rylands and Fletcher, Sturgis and Bridgman, Entories and Miles Far East Corporation, or Donoghue and Stevenson, amongst many, many others, where the law of obligations encountered issues from previous industrial revolutions, such as the development of factories and mass production, or newly developed technologies. Now, as Zimmerman notes in his great book on the law of obligations, previous technological changes and their accompanying social changes radically reshaped the law of obligations. And you can't ignore developments to the law of obligations, which were driven by advances such as the steam engine, the motor car, mass production, the printing press, modern communications, photography, computing, the internet, and so on. Now, the new AI revolution will generate challenges for the law of obligations. And that's readily apparent, not just from our prior experience with industrial revolutions, but also from certain features of AI, including autonomy, complexity, opacity, data-drivenness, vulnerability, unpredictability, the distance between the systems and those responsible for them. And this will generate significant problems for our existing legal settlement. And also it threatens to undermine some of the key rights that are protected by the law of obligations. Now, our previous experience shows that such legal developments will impact more broadly within the law of obligations, and not simply when the doctrines interface with the new technologies. Now, our interest in obligations and its interface with AI is also relevant, given that the law of obligations can have a regulatory function. And it's particularly important in a UK context if the UK continues down the proposed path of a light touch regulation approach towards AI. Now, our handbook contains 11 chapters dealing with various aspects of the law of obligations. And given the limits of time, I'll only be able to very briefly introduce you to the key themes of each, hopefully without oversimplifying the author's key arguments. Now, our first 3 obligations chapters focus on contract and consumer law. Sale of goods is dealt with later. And in chapter 3, T.T. Arvind deals with AI-infused contracting. And he argues that AI has the potential to overcome problems concerning the existing approaches to contract drafting, management, and implementation, whilst also having the potential to exacerbate the pre-existing problems. Now, Arvind notes that the nature of algorithmic systems may make it easy for these systems to lapse into contract law minimalism, unless the systems are expressly designed not to do so. So he proposes a relationally informed principle of transactional responsibility, which he argues should be infused into the way AI contracting systems are designed, deployed, and regulated. And further, he proposes that contract law itself will need to change, specifying disclosure and transparency requirements so as to require the provision of accessible explanations as to how the relevant AI-infused contracting systems function, make decisions, exercise discretions, and are assured. Now, the next chapter has already been touched upon by Ernest, so I won't deal with it in any depth. But in this chapter, Anthony Casey and Anthony Niblett examine the role of AI within automated private contracts. And they examine existing technologies and consider how they could be used to create self-driving contracts. For instance, potential uses of such contracts include dynamic pricing clauses using a pricing algorithm instead of a human arbitrator, or refitting litigation prediction systems for the purpose of allocating and automating terms regarding contractual non-performance and the filling of contractual gaps. They demonstrate that this technology can be used now. This is not simply science fiction. In chapter 5, Janie Patterson and Yvette Maker examine consumer protection law and AI. Now, consumers are at the forefront of market uses of AI, from targeted advertising, differential pricing, and automated decision-making for services. And there are myriad consumer uses of AI products to assist them in their everyday lives. However, they have the potential to endanger consumer autonomy and welfare, ranging from erosions of consumer privacy, the perpetuation of undesirable bias and unlawful discrimination, susceptibility to hacking and security issues, to proving unreliable and unsafe. And such systems collect large volumes of data on consumers. And the insights provided by such data may also be used to nudge consumers into making decisions which might not be welfare enhancing and which are not autonomous decisions of the consumer. And in this chapter, Patterson and Maker advance there's a need to recalibrate consumer protection law to AI. And they also suggest the possibility of fiduciary duties for some systems, such as digital assistants, or given the scope of the potential intimate relationships between smart devices and consumers, that there may be scope to expand the doctrine of undue influence. Now, chapters 6 to 10 of the handbook focus on tort law. In chapter 6, I advance that the existing tort law is poorly suited to address a number of AI challenges. And in particular, a liability gap will emerge as systems replace employees, as AI does not have legal personality and cannot commit a tort. Chapter 6 examines a wide range of alternative claims and alternative liability proposals. And I then propose a form of AI statutory vicarious liability to apply in commercial settings to address the liability gap and as the tech impartial solution. Now, this liability gap has been acknowledged by the UK Parliament, who've introduced the Automated and Electric Vehicles Act 2018. And the UK has been a first mover in preemptively legislating for AV accidents. And in chapter 7, James Goodcamp subjects the Act to a detailed analysis, and he identifies a previously unarticulated, inappropriate statutory preferencing towards victims of AV accidents contained within the statute that does not appear to have been identified by the Act's architects. In chapter 8, Sandy Steele deals with causation. Ernest has already touched on Sandy Steele's chapter. And Sandy examines private law's causal roles in an AI context. And in particular, he identifies two core problems: the problem of proof due to opacity and also autonomy. And Steele notes that if AI is capable of being considered an intervening agent, this would mean that using AI would have liability avoiding effects. Time does not allow me to give this chapter scholarship justice, and I would really recommend it to you all to read. Now, increasing use of AI systems will mean that there's a consequent shift from liability for human errors to liability for malfunctioning products. And this will bring product liability to the fore. In chapter 9, Wiebe Ulfbeck focuses on product liability law and AI. And she argues that AI will greatly challenge product liability. This is since it's based on assumptions as to physical objects distributed through organized linear value chains, and it channels liability to the producer as the best risk avoider. However, she notes that with AI, systems may be distributed differently, and there may be much more complex value chains, and more in the nature of a network. Further, AI blurs the line between product and service, and she advances that the realities of a new value chain calls for a number of adjustments to central product liability concepts. Now, in chapter 10, John Zerilli focuses on the problem of deepfakes which use AI and the appropriation of personality. And he considers privacy law and demonstrates that currently such an appropriation of personality is only actionable if the circumstances disclose one of a number of largely unrelated causes of action. Now, Zerilli demonstrates that the inadequacy of the existing causes of action to protect claimants from the appropriation of their personality, and he argues for a new independent tort for the appropriation of personality. Now, underlying many of the problems regarding the interface between the law of obligations and AI lies the issue of agency. And in chapter 11, Daniel Seng and Tan Chen Han deal with this issue. And they reject the arguments for AI agency and argue that the AI agency problem is overstated, and that many of the issues concerning AI contracting and liability can be solved by treating artificial agents as instrumentalities of persons or legal entities. It's a really interesting argument, and the chapter is very much worth reading. And they advance that this approach best accords with their functionality, and they place the correct duties and responsibilities on their human developers and operators. In chapter 12, which addresses trust law, Anselmo Reyes makes the case that AI will greatly assist in the administration of express and charitable trusts, and should also be of significant benefit to trust law in acting as an adjudicator. And Reyes considers that AI should be able to act as an acceptable trustee of an express trust. Chapter 13 concerns unjust enrichment. Data is key to AI, and it's a valuable commodity, which is collected and sold. In chapter 13, Ying Hu addresses whether data subjects should be allowed to seek gain-based remedies against defendants that collect or use their data to train, develop, or improve their systems, or have sold their data for such purposes. And Hu argues that one advantage of a gain-based remedy in this context is that it may be relatively easy to ascertain the gain, but demonstrating a loss will be considerably harder. Further, a defendant may seek to defeat a class action for losses by requiring individualized evidence on loss from each putative class member, whereas the benefits received by a defendant from unauthorized data collection or use can often be established without requiring each claimant to provide individualized evidence. Hu advances that unjust enrichment is a plausible cause of action for individuals whose data has been collected and used without their consent, and the disgorgement of profits may be possible in some situations. However, the chapter acknowledges that contractual preemption may limit the utility of claims in unjust enrichment in solving this problem. Now, time prevents me from dealing with many of the myriad issues within the book, or even the other sections and chapters, but I hope I've given at least some of the work within the section on obligations fair coverage. Now, AI offers the potential to revolutionize not just the law of obligations, but in fact all areas of private law. It has the potential for significant consequences within the law of obligations as well. Now, it's not possible for this handbook to answer all such questions concerning obligations or private law and AI. And indeed, new questions will arise as the technology develops further and as the direction of societal change becomes clearer. But our handbook aims to prompt debate. And we hope that the issues and debates that we raise in the handbook prove of use to future scholars, policymakers, and legislators and practitioners who are grappling with the ramifications of AI. Now, AI has the potential to unlock great benefits for society, as well as engender great harms. And private lawyers will need to have the right tools and the right questions to ask to play their part.
Thank you very much, Philip, for giving us such a great synopsis of a good number of chapters in the book. And as academics, I think we rather enjoy kind of framing and conceptualizing some of these gaps and ambiguities in law. However, where industry is concerned, the perceptions of these legal risks, might not be so welcome, and an urgent lack of legal clarity might be a pressing problem. With that in mind, I would like to invite Dr. Raphael Reims, or Reims, if I've got your last name correct, to take the floor. Raphael is a member of the advisory panel for the center, and he's a lawyer and compliance expert at the BMW Group. He's very kindly given up an hour of his time to be with us. We look forward to hearing from you with regard to your point of view from industry. Raphael, please.
Well, first of all, thank you for the opportunity to participate here and for the very interesting observations so far. When I was asked if I could illustrate how AI impacts the workplace in practice, I thought immediately of the AI compliance prototypes, which are in the process of being developed at compliance departments of several companies. I believe that these prototypes provide a very good overview of how AI can make day-to-day work easier, but also of the challenges that still exist. The technical platform for these AI compliance prototypes can be based, for example, on the Microsoft Azure cloud, which provides generative AI, which in turn is based on OpenAI's ChatGPT. These AI compliance prototypes are essentially chat systems that are trained with internal compliance codes, regulations, guidelines, and other documents. For example, with a code of conduct, but also with internal compliance regulations and guidelines on competition law, anti-corruption, human rights compliance, etc., as well as with an internal description of a company's compliance management system. As mentioned, these AI compliance prototypes act as a chat box. Unfortunately, many companies prefer not to show internal things to the outside world, and I am also bound by this for this meeting. But I'm happy to give you a few examples on what you can do with these AI compliance chat boxes. So you may get easier and faster access to relevant compliance documents instead of searching them on various internet sites of the different departments. You can get summaries of specific parts of these documents and ask for explanations in a simple language style. You can get answers about the admissibility of external activities, for example, meeting members of other companies, or can ask about the admissibility of value limits, for example, when you receive gifts from external partners. You can submit email consultation requests, which you get, and then get answering email drafts. And you can ask your questions and get answers in varied language, which is helpful for companies that act all over the world. All of this is very helpful. However, there are also one or two challenges that need to be considered. For example, one challenge concerns the protection of information. If you use Microsoft, Microsoft helps in guaranteeing that the data does not leave the Microsoft cloud. in particular that they are not used by OpenAI for training other AI systems. The most critical challenge, however, is still that AI-generated content may be incorrect. And many companies have therefore decided to initially only release their AI compliance prototype to their compliance colleagues so that they can assess its answers and only release it to all other employees at a later stage, at least after an extensive test phase. And then one day it could be very helpful, for example, if an employee could upload a meeting agenda of a meeting with external companies and associated emails and receive a 100% correct compliance, competition compliance assessment regarding the admissibility of the exchange and specific compliance guidelines for this meeting. However, one concern that would likely to arise more frequently then as a result, and is already being voiced by some observers, is of course that this would threaten their own job positions. I understand this concern, but I don't see this concern as very significant. So in my opinion, this would only result in the reduction of the many small requests for compliance advice, which perhaps do not always need to be made if internal compliance regulations and guidelines are carefully checked beforehand. And in this way, compliance colleagues would then be able to devote more time to more important issues than this small kind of requests, and perhaps can go to their loved ones at home earlier from time to time. I hope this has given you a good insight into how AI impacts the workplace nowadays, for example, in compliance departments, and how it could impact the workplace one day.
Thank you, Raphael, for this illustration. It is very interesting, and I possibly have a couple of questions for you after, but I will ask our next speaker to come on first before we run the Q&A session. So our next speaker on the panel is Mr. Nick Pelosi, who is Associate Director of Engagement in North America of EOS Hermes. He also authored the EOS Digital Rights Principles. Nick is trained in interdisciplinary areas, and I believe you are not a lawyer in terms of your core training, which is of great interest to us, because I hope you'll be able to bring basically a more interdisciplinary voice to this area where we are in great need of interdisciplinary ideas and fertilization in terms of our perspectives. So over to you, Nick, in relation to how, as an asset manager, you engage on this area of digital rights and business risk in relation to AI.
Thank you, Iris. I represent EOS at Federated Hermes, which provides stewardship services for asset owners and asset managers. We engage with companies to improve long-term returns for investors and promote better outcomes for society. Our clients are investors in the companies developing and deploying AI technology, and our clients are interested not just in short-term productivity gains, but in long-term impacts, risks, and opportunities. So for us, AI is first and foremost an engagement topic with companies. We published our own principles on ethical AI back in 2019 and have updated them periodically to reflect changes in the field. AI is now part of our policies on digital rights, which we define as human rights online. And we encourage companies to adopt their own policies on ethical AI and to show evidence of implementation. Regarding AI in private law, we're often asking companies about their preparedness for compliance with current or emerging regulations, which are coming in many markets. However, the technology is often advancing faster than regulations can regulate it. And there's always potential for deregulation. And so that is why we think a compliance approach should be supplemented with a risk management approach that is underlined with ethics and a meaningful commitment to do no harm. We encourage companies to adopt ethical AI policies. Many companies do already have them in place. Some of the most verbose policies on paper are actually coming out of the tech sector, the companies on the front lines of producing these technologies. The big 5 to 7 tech companies have pages of disclosure on how they're doing it responsibly, what are the range of purposes for which they're using AI, and what variables they take into account. Of course, having policies on paper is just the first step, and it's important to show evidence of implementation. We like companies to share use cases or case studies showing how these policies work in practice. There are obviously many ways for AI to be used for good. There's AI for healthcare, AI for education, food security, pretty much every sustainable development goal. But we also want companies to be transparent about where there is potential for harm or misuse of the technology, or where there are ethical dilemmas or trade-offs. For example, in the tech sector, there can be trade-offs between privacy and security. And on social media, there's trade-offs between freedom of expression and the need to moderate content. And so these are the types of trade-offs that show how the rubber hits the road when it comes to operationalizing these policies. Much of our engagement on AI recently has focused on social media, encouraging companies to reduce the spread of problematic content on their platforms, strengthen safeguards for users, including children and teen users, to ensure responsible harvesting of data for AI by obtaining user consent, and then responding to the quickly emerging issues related to generative AI. The cat is sort of out of the bag on that. There are standards emerging around transparency and watermarks that can be used to detect generative AI. But where we've challenged the tech sector is to prove to us that their business models do not incentivize the spread of problematic content on their platforms. And we do have quite a bit of public disclosure on our website describing that engagement on social media. Another ethical trade-off that we're grappling with is the question of, when does AI replace a worker? Many of our clients are pension funds, and so there is strong interest in the intersect of AI and workforce issues. We ask companies to show how their deployment of AI is affecting their workforce, and ideally show net positive changes to the workforce. And this is not just the tech sector, but all sectors using this technology. Historically, like with the Industrial Revolution, the advancement of technology has had net positive effects on jobs. But we're thinking about how long that assumption will last, and how will AI affect not just the quantity, but the quality of jobs. We know that the workforce is changing as we speak, but we know less about how. And so that's what we want companies to tell us. There are human capital metrics, best practices are evolving to take this into account. For example, the Workforce Disclosure Initiative metrics now ask companies to provide the number and/or percentage of employees that have been reskilled, redeployed, or had their employment terminated as a result of automation. Most companies aren't producing this information yet, but we'd like them to. And there's also a clear role for academia and civil society in helping to produce this data. Another way to test these policies to make sure there are processes to identify, manage, and mitigate unintended or unwanted bias. There is a broad range of actions that companies can take, from internal checks and balances to third-party racial equity audits. For us, it's not just about having the processes in place, but also having diversity in the AI team and in the leadership of the company. We view robust diversity at the company as a prerequisite for any company looking to effectively address these biases. And finally, we look for evidence of board oversight. It is obviously important to have good governance. It is helpful for companies to designate or assign board oversight to the charter of one of their committees. Boards are generally wanting to show that they're on top of AI given the hype. However, it's less common for AI to appear in the director skills matrix that companies usually put in their proxy statements. And so that's probably the next step we can ask for boards to codify that expertise via the director skills matrix. And so in conclusion, we engage with companies on AI to mitigate risk. Doing these things voluntarily will help reduce the cost of compliance with any regulations that are forthcoming, but they can also mitigate the risk caused by lack of regulations or the absence of regulations. That risk manifests in other ways, whether it's reputational risk, operational risk, or simply the risk of a dysfunctional society. And so on a positive note, we see AI as an opportunity to progress the important topics of digital rights, which were here before, an opportunity to revisit those and make sure AI benefits everyone. Thank you.
Thank you very much, Nick. I think we have about 10 minutes for Q&A, which is a good amount of time. We already have one question in from Eva Michaela at the LSE for our editors. And it is a lovely as well as tongue-in-cheek question. Was AI used in the production of the chapters of the book? And if yes, how? And if not, why not? So this one, I'll give it to the editors to answer.
Well, I will speak first, and then, Philip, you can chime in. I personally did not use Gen AI with respect to the production of the book, with respect to the editing of the book. I am not aware, to the best of my knowledge, as to whether any of the contributors use generative AI in writing the book chapters. I'm personally not aware, but I think her follow-up question is why I did not use generative AI, for example. Well, there are three major problems with the use of Gen AI, whether for editors with respect to editing or there are also risks to the contributors if they use Gen AI. One major risk that we all know is Gen AI hallucinates. Generative AI could actually invent fake authorities and fake cases. So one has to be extremely careful in using Gen AI. The second problem is that if one uses Gen AI to assist one in writing the chapter, there could be a potential breach of IP rights as well. So this is the other thing that authors, contributors, editors have to be extremely aware of. And I think the third major risk of using Gen AI is breach of confidentiality, because if you have certain key ideas or important ideas that are confidential or ideas that you do not wish to be shared so widely, the inputs that the prompts that you enter into the AI system could be used by OpenAI, and as well as the other tech companies to train its own model. So one has to be extremely careful, in terms of the prompts that one has entered or the data that one provides to these Gen AI system. So for these three reasons, potential hallucinations, potential breach of IP rights, and potential breach of confidentiality, I personally did not use Gen AI in editing or in the production of the book. I'm not sure about the rest of the other authors.
So yes, just to add a short aspect to that, Ernest has covered, I think, the core problems of using generative AI such as ChatGPT. I did not use it, and I'm, to the best of my knowledge and belief, no one else did either. This is a common problem that most of us academics are facing with student work at the moment. And it's a real ethical problem in the production, particularly of scientific literature, the use of Gen AI in the production of articles. And some do think that you can use it as a tool and then tailor it appropriately afterwards. But I would counsel against that. The first one Ernest's mentioned is hallucination. For any students watching this, this is my quick method of finding out who's using Gen AI on their courseworks. It's the made-up cases. It's the made-up articles. They look plausible, but they're not. It's the descriptions of cases or the analysis of cases which are fundamentally unsound that gives away the use of Gen AI. So the quality of Gen AI is nowhere near that required for detailed publishable legal analysis as required by the handbook. The second reason I would counsel against anyone using it, in addition to the reasons given by Ernest, is we want people to think differently. Using Gen AI has a risk that will simply replicate existing thought and bias. You're not necessarily going to be approaching the problem afresh. It's going to be generating its data based on what's been said previously. And finally, we've got the issue of inadvertent plagiarism. That is a real risk of using Gen AI. What's its data source? What's its drawing? What is it drawing on? Is it plagiarizing an article unknown to the person who's using the Gen AI system? So the risks of plagiarism are also extremely serious for anyone using this for the production of scholarly, particularly serious scholarly publishable work. So to the best of my knowledge and belief, this was not used in the editing or writing of any of the chapters, nor in my view should it be.
Thank you to both the editors, and I think your remarks have wider application in terms of what circumstances Gen AI may be used legitimately as well as efficiently. And for that, I mean, if you don't mind, I would turn to Raphael with my question, because I was fascinated by your account of how the AI compliance prototype is being developed, and how you are kind of testing it out and using it. I'm just wondering, at this earlier stage, there might be inefficiencies actually of human beings having to keep verifying and testing it. Do you see these systems becoming mature enough that you can actually harness the efficiencies? Or do you think that this constant verification, this constant testing is just going to carry on because of the dynamic nature of these AI systems? What are your thoughts, Raphael?
Thanks for the question. I think I must give a typical lawyer answer, which is one might see, and it depends. So it is really hard for me to predict that. I would say for the internal use of compliance colleagues, these kind of prototypes can be very helpful, and they are saving time because you can get an email like a consultation request by other employees and have maybe an answer drafted, and then you can for yourself check it, and I think you can save time by that. So what I meant when I was saying that we are right now that companies are right now in the process of a testing phase, I would say that they are. What I wanted to say is that they are testing that on the job with their current duties that they already have. So there is no extra work on that. So I would consider it right now to be already helpful. I'm sure because everything develops and gets better, that in the near or middle future, it will help even more and will become less time consuming.
Right, thank you, Raphael. I think one of the areas or one of the issues I'm very interested in is really this spectrum of reliance, of human reliance on AI, and how far will it slide, and as it slides, at what point are we going to say that there is a trade-off between efficiency and just kind of lack of either imagination or criticality or even scrutiny. I mean, these are the things that are rather important, maybe, and this is why there is a lot of ex ante calls to build in explainability, accountability, etc. But these mechanisms are still in their emerging stages. Are there any questions within the panel for each other? I'll be really happy to facilitate that as well, if there are any questions kind of intra-panelists.
Perhaps one from me for our industrial panelists. I'm working on a project at the moment with Bradford NHS, and we're looking at simulating different models of AI advisory system to be used in clinical decision making. And we've modeled a variety with clinicians. We've carried out simulations. And we were looking at sort of how behavior and clinical decision making would be affected by different models of AI and different models of explainability. And I'm just wondering, from our industrial panelists, have you seen in your work any change in how decisions are made as a consequence of AI being present in the workplace, or support systems being in place that, or advisory systems that you have or have seen in operation? So is it changing how people make their decisions? Firstly.
So in my team, we've been exploring a number of different ways to operationalize AI to make our own engagement more productive. Offhand, I can't think of cases where it's affected decision-making, but it is for sure affecting the broader field of investment decision-making. There's significant amounts of data that goes into trades on a daily basis. And I think investors see value in the speed and scale with which AI can capture that data, including from unconventional sources such as social media, and then use that to inform stakeholder perceptions and, by extension, a valuation of the company.
Right, thank you, Nick. Any other question from the panel? Or I don't see any Q&A coming in from the audience at the moment. I think if not, then we will wrap up this panel and call it to a close. Thank you very much to my panelists for providing such a wonderful synopsis of the book, as well as for the perspectives and the input from asset management and from industry. I'm really grateful that you've given your time this lunch to be part of this webinar. And hopefully we'll be able to offer this recording to stream on YouTube as soon as is possible. So thank you very much once again for being part of this panel. And we look forward to seeing you at some point in time in our events or in other ways in which our paths may cross. Thank you.